I'm Gleaves Whitney, and I'm proud to serve as director of the Hauenstein Center for Presidential Studies here at Grand Valley State University. Good evening. Thanks for being here. You know, it's useful every once in a while to restate what an institution's purpose is, and since this is our first coffee house debate of 2015, I'd like to take a moment to tell you what we're about. Again and again, I'm approached by people who come up to me, a program like this, and they say, what are you going to do about the mess that's in Washington right now? You know, look at the gridlock, the ideological gridlock, the cynicism. Look at the dysfunction and corruption that dominate the headlines. Aren't we better than that? And I always like to say, yes, we are better than that, and we do deserve better than that. We don't want any more sordid headlines. So what are we doing about it? I first remind them that we are West Michigan, where leaders like President Gerald Ford, Senator Arthur Vandenberg, and Congressman Paul Henry knew how to work in institutions, democratic institutions, that could absorb robust debate. They could nevertheless come together and solve problems despite their disagreements. And our best statesmen from the Midwest, I think, could teach a thing or two to people in other parts of the country. Second, I point to another West Michigander, our center's founding benefactor, Colonel Ralph W. Hauenstein, whose career exemplifies the ethical leadership and public service that we like to instill in Grand Valley graduates. You know, in World War II, Ralph played a key role in one of the most dramatic common ground initiatives in human history. That initiative, of course, was D-Day. And Ralph learned a lot of harrowing lessons from that experience, and he's passed those lessons on to us. Third, in 2012, with the help of an NEH grant, the Hauenstein Center launched the Common Ground Initiative to encourage the principled exploration of clashing policies and clanging philosophies in our public square. Now, our goal is not to turn Democrats into Republicans or Republicans into Democrats. Our goal is not to create operatives in the middle of the road who would sacrifice principle for process. Rather, our goal is to raise up leaders who have the skill and understanding to work among diverse people to find common ground for the common good. It is the only way that democratic institutions really work. Our Common Ground Initiative is premised on the idea that a free people will always develop at least two different factions. For simplicity, let's boil them down to the party of innovation and the party of conservation. American history mostly happens where these two forces collide in the public square. They learn how to compromise and accommodate each other before they collide again. It's an endless drama in the American narrative. We all know it. We've all experienced it. I like to think of the metaphor of the triptych. You've been to an art museum where you see a triptych or 3 panels of paintings, and you have the left panel and the right panel and the big center panel. Well, for simplicity, we can think of the left panel as the party of innovation. We can think of the right panel as the party of conservation, and there's a lot of drama going on in those 2 panels. But where the main drama takes place, where the real storyline of American history unfolds, is when those forces come together in the big center panel. And sometimes the result can be quite harmonious and beautiful, and sometimes it can be quite discordant, and sometimes downright ugly. Democrats versus Republicans, progressives versus conservatives, North versus South, Hamiltonians versus Jeffersonians. It's happened throughout American history. There's always one group that wants to slow down the pace of change and conserve our institutions, while another group wants to speed up that pace of change and get on with reform and innovation. The art of leadership in this environment, the art of politics in our democracy, is to find principled ways to leverage these clashing forces for the public good. And that's one of the reasons we focus on the presidency at the Hauenstein Center. The president is the one elected official with the vice president, elected by all Americans who vote. They always have to be able to deal, they have to see the common ground that's possible, and they have to be able to deal with people with whom they disagree. Now, our Common Ground initiative is unique in higher education today. No other public university in the United States is making a balanced, comprehensive exploration of what it means to be conservative and what it means to be progressive in the 21st century. Our wheelhouse talks inspire leaders. Our American conversations engage citizens. Our coffeehouse debates, like tonight, inform voters. In all of these forums, we explore these two traditions and search out the common ground that they might share historically, culturally, and politically. Now, at Hauenstein Center programs, you're not always going to hear people you agree with, and that's a good thing. We hope to bring you a diverse hearing of these issues, programs built on the conviction that intellectual excellence is built on diversity and academic rigor. Our Common Ground initiative seeks to create a space where conservatives and progressives can come together and, in an open, respectful, intellectually rigorous forum, confront the challenges we face. I hope you'll ask us about our many programs. We've hosted over 400 programs now, everything from Hitchens v. Hitchens to having Arianna Huffington and Victor Davis Hanson come in and debate and mix it up. Go to hauensteincenter.org and look at the excellent work we do. Get involved. Help us in this project to demand accountability from our public officials and demand that more people seek out common ground, principled common ground, not just the middle-of-the-road squish stuff, but the principled common ground that makes our democracy work. Let me thank you for all of the ways that you've supported the Hauenstein Center. Your presence here tonight is an expression of that support. It is now my honor to introduce my colleague, Joe Hogan, who's the program manager for our Common Ground Initiative. Thank you.
Thanks, Gleaves. It is my privilege tonight to introduce our moderator, Magistrate Judge Hugh W. Brenneman, Jr. Judge Brenneman received his J.D. from the University of Michigan Law School. He then served for 4 years in the Judge Advocate General's Corps. After that, Judge Brenneman worked as an attorney for the Western District of Michigan and in private practice before becoming a United States Magistrate Judge, a position he's held since 1980. Judge Brenneman is a fellow of the State Bar of Michigan Foundation. He's co-founder and inaugural president of the Western Michigan chapter of the Federal Bar Association. Judge Brenneman is also co-founder and past president of the Gerald R. Ford chapter of the American Inns of Court and co-founder of the Historical Society for the U.S. District Court for the Western District of Michigan. Indeed, Judge Brenneman has a great deal of experience in parsing through and sorting out legal issues such as these. His experience, in fact, has revealed to him that he really ought to bring a marshal, a plainclothes marshal, to events such as these. Not to protect him, but to protect Hans and Ian from each other. We're very pleased to have Judge Brenneman with us this evening. Please join me in welcoming him.
The events leading to the adoption of our First Amendment are well known to you. In the 6 years following the British defeat at Yorktown, the 13 former colonies had fared poorly. The Articles of Confederation adopted during the war had given the Continental Congress no power to regulate trade, and the states had levied import taxes on the neighbors. The Confederation had coined no gold or silver because they didn't have any. Instead, they had printed vast sums of paper money to pay war debts. Inflation, predictably, was rampant. And in some places, the price of tea exceeded $100 a pound. Congress could declare war, but it had no power to tax. Congress was helpless to put down an armed insurrection in western Massachusetts that had threatened to seize a federal arsenal. Indeed, the individual states were stronger than Congress. 9 had their own navies. The Republic had no judiciary, no Bill of Rights, a weak executive. For strong economic reasons, the Articles demanded amendment. And thus, in the summer of 1787, the state sent delegates to that magnificent chamber in the State House on Chestnut Street in Philadelphia that had witnessed the signing of the Declaration of Independence 11 years earlier to amend the Articles. History remembers that as a brilliant assemblage, graced by Washington and Franklin, Hamilton and Madison and the like. 7 men had not reached the age of 32, and only 6 were over 60, but all were accomplished. 34 were lawyers and judges. 37 had served in the Continental Congress. 21 had fought in the Revolution. 14 had been governors. 3 had founded colleges. 1 had captured electricity in a jar. They quickly determined the Articles could not be salvaged. They closed the windows and barred the doors and sat down to write a new Constitution. But even this collection of American demigods, as Jefferson would call them, men history celebrates as the founding fathers of their country, were unable to write a document that could be ratified without the promise of a Bill of Rights. This became one of the first orders of business of the new government. The first of these amendments, which became effective in 1791, states in pertinent part, Congress shall make no law abridging the freedom of speech. It's been argued, as we shall see, that during this era, free speech was considered an individual, human faculty, and that this idea was deeply rooted and made manifest in the writings of Locke and Milton and others on whom the framers of the Constitution and the Bill of Rights relied. Now, parenthetically, the First Amendment states that Congress shall make no law abridging freedom of speech, yet today we recognize that it is not an absolute prohibition. The Supreme Court has held that a balance must be struck between First Amendment freedoms and a government's need to govern effectively. For example, language may be regulated where it creates a clear and present danger. So I would ask people in the audience in this theater this evening, please do not yell fire. Unless you actually see a fire, then please yell fire. The court has consistently placed obscenity outside the protection of the First Amendment. If something is obscene, you'll probably know it if you see it. Commercial speech may be regulated, and libel is not protected. On the other hand, a symbolic gesture such as flag burning may be protected as a substitute for speech. More recently, the court has recognized that restrictions on political donations may violate the right to free speech, because virtually every means of communicating ideas in today's society requires the expenditure of money. And indeed, it is such restrictions that bring us to our topic tonight. Well, good evening. My name is Hugh Brenneman, and it's my privilege to be the moderator this evening as we debate the topic, is Citizens United good for American democracy? I'm sure the irony of the title, Citizens United, has not escaped anyone. The case of Citizens United versus the Federal Election Commission, the FEC, was controversial when it was decided by the Supreme Court 5 years ago, and the controversy has been simmering ever since. In Citizens United, the Supreme Court held that the prohibitions in the McCain-Feingold Act, which restricted independent expenditures by corporations and unions, violated the First Amendment's protection of free speech. Justice Kennedy, writing for the 5-person majority, argued that the First Amendment protects associations of individuals as well as individual speakers, and further that the First Amendment does not allow prohibitions of speech based on the corporate identity of the speaker. Corporations, as associations of individuals, therefore have free speech rights under the First Amendment. Also, independent expenditures made by corporations, the court concluded, do not give rise to corruption or the appearance of corruption. Now, Justice Stevens, writing for the 4 dissenters, said that corporations are not actually members of society. He cited Chief Justice John Marshall, for the age-old proposition that a corporation is an artificial being, invisible, intangible, and being a mere creature of law, it possesses only those properties which the charter of its creation confers upon it. As far as regulating speech based on a speaker's identity is concerned, Stevens noted that the government routinely imposes such restrictions, pointing to those restrictions on the rights of students, prisoners, members of the armed forces, foreigners, and even its own employees. And finally, Stevens dismissed the idea that the majority's belief that quid pro quo corruption, that is, the direct exchange of an official act for money, is the only type to be concerned with, because this belief, he said, was not in accord with the reality of politics. Well, the Citizens United controversy simmered, as I said, and was rekindled last April with the court's decision in McCutcheon versus the FEC, sometimes referred to as Citizens United Second, which struck down an aggregate limit on the contributions that people can make as a violation of free speech. And the controversy exploded back onto the front page 2 weeks ago, as 7 protesters were forcibly ejected from the tranquil Supreme Court courtroom in Washington, D.C., something that never happens. The protesters' message was, money is not speech, and corporations are not people. But if our citizens are not united, it is nevertheless the hope of the Hauenstein Center for Presidential Studies that by the time we adjourn this evening, perhaps we will have reached a bit of common ground. Perhaps there are points that we can agree upon. We'll see. We're extremely fortunate to have with us this evening 2 of the country's most knowledgeable gentlemen on this timely topic, and I do not exaggerate. They are Ian Millhiser from the Center for American Progress and Hans von Spakowski from the Heritage Foundation. I'm sure you have read their commentary in the New York Times, the Wall Street Journal, U.S. News and World Report, the Washington Times, Politico, or the Huffington Post, or other publications, or have seen them on CNN, MSNBC, Fox News, or many other outlets. Mr. Millhiser, who is on my immediate left and your left, is a senior constitutional policy analyst for the Center for American Progress and is the justice editor for the Center for American Progress Action Fund. He has previously been a policy analyst and blogger for Think Progress. He's a graduate of Kenyon College and the Duke University Law School, and he's worked for the National Senior Citizens Law Center, the American Constitution Society, and Teach for America. He also clerked for the Honorable Eric Clay of the Sixth Circuit Court of Appeals. Our district is in the Sixth Circuit, and since I don't recall Judge Clay ever reversing any of my decisions while he served his clerkship,
he is a very wise man, Judge.
I was going to say I must assume that Mr. Millhiser is a fine chap. Now, Mr. von Spakowski is a senior legal fellow at the Heritage Foundation's Edwin Meese Center for Legal and Judicial Studies, where he is also manager of the Heritage Foundation's Election Reform Initiative. He's a graduate of MIT and the Vanderbilt University School of Law, and he's previously served on the Federal Elections Commission and in the Department of Justice. Since he and I have both been employed by the Department of Justice, I have to assume he's a fine fellow as well. In all candor, however, Mr. von Spakowski has recently written a book about our present Attorney General that would suggest that merely being affiliated with the Department of Justice does not automatically ingratiate you with him. You may wish to read his book. I'll be serving as your host. Since being appointed as a federal judge 35 years ago, I have been unable to campaign for or contribute to any candidate or political party. I was selected as a judge on a nonpartisan basis, and I remain as non-political today as I was then. If Gleaves Whitney was looking for a political eunuch to moderate this debate, here I stand. In a moment, I'm going to be turning the microphone over to the first of our speakers. The order of speaking was determined earlier this evening by the toss of a carefully inflated football. Well, it seemed like a good idea. Actually, we flipped a coin. Mr. Hans von Spakowski will go first. Each speaker will have 10 minutes to make his initial presentation with 5 minutes for rebuttal. We'll then open it up to the audience for questions, and I'm confident everybody will be on their best federal courtroom behavior. Finally, I will give each speaker a closing minute for any final thoughts, caveats, disclaimers, mea culpas, apologies, or retractions. Before we begin, there are a couple of terms we ought to be familiar with from the outset that might be confusing. And I will, of course, defer to our speakers to elaborate. On these points, they are the experts. The first is the word contribute. A contribution is money given to a candidate or his or her political committee. Now, by contrast, an independent expenditure is money spent that expressly advocates the election or defeat of an identifiable candidate. But this money is not considered a contribution because it is spent without collaborating with a candidate or a political party. So when Butch and Dave and I were in second grade in 1952, and Eisenhower was running for president against Adlai Stevenson, and Dave, whose father had been a colonel in World War II, wanted to support Eisenhower, he sent his 50 cents directly into the Eisenhower campaign. That was a contribution. Butch didn't have 50 cents, but he did have a lot of paper and crayons, and he made a lot of signs that said, "I like Ike, but I'm voting for Adlai." And he posted them on trees all over the neighborhood. To the best of my knowledge, Butch never called up the Democratic Party headquarters to coordinate this with Adlai's campaign. Today, these would be considered independent expenditures. I, of course, was nonpartisan. As things stand today, after Citizens United, Dave would be able to contribute money directly to General Eisenhower, but would be limited to a several $1,000 cap. Butch could give unlimited millions to a super PAC, Political Action Committee, that could plaster airwaves with TV ads saying, "Vote for Adlai," as long as the super PAC did not coordinate its ads with Adlai's campaign. Of course, Butch would be listed as a donor to the super PAC. If Butch wanted to achieve the identical result anonymously, he could give his unlimited millions to what are called social welfare nonprofits. These are 501c organizations that can do the same thing super PACs can do, but don't have to identify their donors. In fact, they can just pass the money to a super PAC, which only has to list the 501c organization as the donor. Some of these are well known: the NRA, Planned Parenthood. Some are newer, such as the Koch brothers' Americans for Prosperity and Karl Rove's Crossroads GPS. And now, there are no caps restricting corporations or unions from spending all of their money independently, but on behalf of or in opposition to a candidate. According to the New York Times a week ago, in last year's 2014 election, the 100 biggest donors spent more money than did the 4.75 million Americans taken together who made donations of $200 or less. In next year's 2016 election, it's estimated that nearly $8 billion will be spent on the presidential and congressional elections. Question: is Citizens United good for American democracy? Let's hear what the experts have to say, shall we? Mr. von Spakowski, your thoughts.
Thank you, Judge. I have to say that was the best explanation of the difference between a direct contribution and independent expenditure I've heard, especially the thing about pictures with crayons. I brought a copy of this great book that the Hauenstein Center puts out. It's got the Declaration of Independence and the Constitution in a very handy size that you can keep in the inside pocket of your jacket. And I thought I should pull it out because, the First Amendment is very clear, very simple. On the part that we're concerned about says, Congress shall make no law abridging the freedom of speech. It doesn't say Congress can abridge the speech of certain individuals or certain associations or unions or corporations. It says Congress shall make no law abridging freedom of speech. Yeah, there are some exceptions that the judge talked about. For example, prisoners in state penitentiaries, there could be some limitations on that. There are other limitations for clear and present danger, but It's a pretty simple amendment, and I'm here to tell you that I think the Citizens United decision was a good decision, and I think it restored a vital part of the First Amendment that had been restricted by Congress. Now, it's important for you to understand that there were two provisions at issue in that case. And before I get into it, I want to talk about what the case was actually about. Citizens United was a nonprofit, small organization in Washington, and they decided to make a movie about Hillary Clinton. It was called Hillary the Movie. Now, this was not any different than the kind of documentary you might see on HBO. It was not very flattering to Hillary. It interviewed a lot of people who had worked and known her who didn't have very nice things to say about her, but nowhere in the movie did it ever say that people should vote for or against her. Okay, it was a documentary about her. Now, they wanted to run ads starting in January 2008 to have people buy the movie. Some of it was shown in theaters, pay-per-view, DVDs. They could not run an ad advertising their movie because if they did, they would violate federal law. Now, why is that? Well, the ban on corporations being able to contribute directly to federal candidates has been in place for more than 100 years, since 1907. But it wasn't until 1947, the Taft-Hartley Act, not only added labor unions to that ban on direct contributions, but in 1947, Congress also passed a second ban. And this one said that corporations and unions, not only can they not contribute directly to federal candidates, but they can't engage in independent political expenditures. And that meant, for example, if the AFL-CIO thought that someone running for president was going to be bad for unions, and they wanted to buy a full-page ad in the, what's the paper, Grand Rapids Press, right? They wanted to buy a full-page ad saying, this presidential candidate would be bad if he's elected president. Don't vote for him. They could not do that. Now, Harry Truman considered that provision such a violation of the First Amendment that he vetoed it and was overridden by Congress. That particular provision, the constitutionality of it never got to the Supreme Court before the Citizens United decision. There were two cases that did get to the Supreme Court concerning that ban on independent political expenditures, which is really independent political speech. They did get to the Supreme Court. In both cases, the court disposed of them on statutory grounds. In one case, I think they said that the provision really didn't apply to what had happened. The dissenters in both of those cases said, no, we should have decided this on a constitutional basis, and we should have thrown out this federal statute because it was a violation of the First Amendment. And I tell you that because the dissenters in those cases, one in the 1940s, one in the 1950s, were some of the liberal stalwarts of the Supreme Court, including Earl Warren, Hugo Black, and William Douglas. So, today you get this picture that it was these terrible conservatives on the court who decided the Citizens United decision. But these earlier, very liberal justices on the Supreme Court said this provision was unconstitutional. Now, Congress made this ban even worse. In 2002, they passed what they called the electionary communications provision. And it said that if you're a corporation or a union, you cannot run an advertisement on radio or TV, cable, if it names a federal candidate and you're within 30 days of a primary and 60 days of the general election. So let's go back to my union example. If Congress was going to pass a law that would ban unions in the United States, and the AFL-CIO wanted to run a national TV ad that said, this is a horrible bill, please call senators, and they named the senators. Let's say in Michigan they named the 2 sitting senators, and the AFL in their ad said, please call, Senator Smith and Senator Jones and tell them, do not vote for this bill. If they ran that ad within 60 days of the November election, which they might have to do if Congress scheduled it for October 15th date, they would be violating federal law. And they could be prosecuted for it. And in fact, the head of Citizens United, David Bossie, was in danger of being prosecuted if they simply ran an ad that asked people to buy their movie about Hillary Clinton. Why? Because she was a candidate for office. So those are the 2 provisions that were before the Supreme Court. Now, I think they made the right decision because it was very interesting. Not only were they banning independent political speech by unions and corporations, but they had a big exception in it. If you were the New York Times company, there was an exception for you. So there was no even playing field there. If you owned a newspaper, if you owned MSNBC or Fox News, I think MSNBC at the time was owned by General Electric, well, you could engage in all the political speech you wanted to. But again, if you were a union or a regular corporation and you wanted to engage in political speech to counter what the editorial page of the New York Times was doing, for example, endorsing a presidential candidate, you couldn't do it because you were banned by federal law from doing it. Now, the notion that the First Amendment only covers individuals is short-sighted at best. Each of you has a First Amendment right to engage in political free speech and engage in independent political expenditures, like, spending your own money to go take out an ad in the local newspaper to say, don't vote for somebody. You don't lose those rights simply because you associate with others in a group. Perhaps get together with 5 of your friends so you can pool your money. And maybe you incorporate for reasons of limiting your political risk. You don't lose your right to speak because of that. Let me give you a quote very quickly that there was a very telling moment during the first oral argument. Remember, that electioneering communications provision just applied to ads, right, on TV and radio. Justice Roberts said to the government, to the Justice Department, he said, well, if Congress wanted to change the law and extend it to books, could they do that? Could the government ban books with a political message if it's produced by a company or a labor union? The answer of the Deputy Solicitor General was, we could prohibit the publication of the book. So what Chief Justice Roberts said was, the government was urging the court to embrace a theory of the First Amendment that would, quote, allow censorship not only of television and radio broadcasts, but of pamphlets, posters, the internet, and virtually any other medium that corporations and unions might find useful in expressing their views on matters of public concern. Now, my answer to speech that people don't like, you don't like the speech that some of these people with a lot of money are engaging in? Well, the answer to that is more speech. And if you don't like what one particular person is saying, speak out against them. And if you want to multiply your voices, then do what Americans have been doing since Alex de Tocqueville wrote about it, which is you join an association that can multiply your voice. And remember, this ban on corporations extended not just to profit corporations, but also to nonprofits like the NRA, Planned Parenthood, the Sierra Club. Doesn't matter whether you're on the left or the right. Let me end by saying this. There are a lot of complex legal issues in this case. But what it boiled down to was this. Do you want to live in an America where somebody can be prosecuted by the Justice Department and put in jail because they produced a political documentary? Because that was the status of the law. I don't want to live in a country like that. That's why I think Citizens United was a great decision. Thanks.
Thank you. Well,
All right, thank you, Judge. Such is the majesty of the law that it allows both rich and poor alike to write $100,000 checks to super PACs. I am going to start with an origin story. And my origin story goes back to the 1970s because much of our modern campaign finance framework was built in the post-Watergate era. It was built then because there was rampant corruption in both the executive and the legislative branch of government. It was bipartisan. One example of the corruption you saw was there was a Nixon operative who literally tried to sell an ambassadorship for $100,000. Literally says, you give these campaigns $100,000, I'll make you the ambassador to Trinidad. That was the deal that was offered. But there were other forms of corruption. An oil CEO said that, testified to Congress that campaign contributions were viewed as a calling card. If you wanted to get in with a member of Congress and speak to them, you had to pay for the privilege. Another CEO, an airline CEO, said that he felt pressured to give donations because he feared that if he did not make them, then Congress would pass laws that advantaged his competitors to the detriment of his company. And so there were two different forms of corruption that were going on there. One is what the judge referred to previously as quid pro quo corruption, dollars for favors corruption. Dollars for favors corruption happens when I walk up to a congressman and I say, here's my money, and if you want this money, I want you to vote yes on this bill, where there's an explicit deal where the money is conditional upon a particular favor. But there's another type of corruption at stake there. When that oil executive spoke about money being a calling card, he wasn't speaking about an explicit arrangement. He wasn't speaking about an arrangement where he said, I've got a particular thing I want you to do, and if you do it, you get the money. He was speaking about dollars for access. I have this money, and with this money, I will buy the privilege of getting in to speak to you, Mr. Very Powerful Person. Flash forward to Citizens United. The holding of Citizens United is it drew a sharp line between those two forms of corruption. Prior to Citizens United, the law had been that, yes, there are strong First Amendment issues at stake when we talk about campaign finance, but campaign finance laws are allowed when needed in order to ward off corruption. Citizens United said that the government can still regulate dollars for favors. So if Congress wants to take steps to make sure that I can't go up to a congressman and say, here's my bribe, and in return for that bribe, I want you to vote this way, Congress can still ban that. But they said that what Chief Justice Roberts once described as mere access or influence, when money is used to buy mere influence or access, that is not corruption. And according to the Supreme Court of the United States, that is not something that our law can prevent. And they actually went even further than that, because there's this interesting passage in the Citizens United opinion where the court talks about this kind of additional access and additional ability to get things done in Washington that donors have as if it was a positive good. I'm quoting the Citizens United opinion with this passage. Favoritism and influence are not avoidable in representative politics, the opinion says. It is the nature of an elected representative to favor certain policies and by necessary corollary to favor the voters and contributors who support those policies. It is well understood that a substantial and legitimate reason, if not the only reason to cast a vote for or to make a contribution to one candidate or the other, is that the candidate will respond by producing those political outcomes the supporter favors. Democracy is premised on responsiveness. Those were the words of the most powerful court in the country. Now, I do not think that democracy is premised on that sort of responsiveness. I believe, and I agree with Hans, that there are serious issues at stake when we talk about regulating the kind of, the way that people can message about an election. That is something we should be cautious about. But we should be equally cautious when we start to say that certain people should have greater access to our government because they happen to be willing and able to pay more money. That is something I also think that the law should prevent. So I think this distinction between dollars for favors and dollars for access is a false distinction. And I think that Citizens United was wrong because it relied on this false distinction. And I'll give two other examples of how this distinction fosters a kind of corruption. Now, the average cost of winning a House race in the United States in the last cycle was $1.7 million. If you wanted to be a congressman, that's about how much money you had to raise every 2 years, $1.7 million. If you want to be in the Senate, $10.5 million. That's the cost of the average victorious Senate race, $10.5 million. You go to Capitol Hill, you walk a little bit down the hill. On the bottom of the hill is a Mexican restaurant, and on the way, you'll pass two buildings. One of them's the DNC, one of them's the RNC. At the top of both of those buildings, there is a phone bank where senators and congressmen literally go every day, sometimes spending 3 or 4 hours a day, dialing for dollars. Our congressmen are glorified telemarketers. And the people that they're calling don't necessarily look like America, because not everyone in America can afford to write them a big check. Now, what the rise of super PACs has done is they have made that process even worse. I've been told by members of Congress they spend about 1/3 of their time now on fundraising. What members of Congress live in terror of is that with the rise of super PACs, a big rush of super PAC money can come in at the end, and if you don't have money in your bank account to respond to it, you're dead. And so they have to raise more than that $1.7 million I talked about, because they have to have a buffer in their account. So if that super PAC shows up with that ad making some spurious claim about them, they have enough money left over to respond. That is more money spent at the top floor of the DNC, the RNC, more money spent dialing for dollars, and that is less time spent learning what they're voting on. That is less time spent with their constituents. That is less time spent educating themselves on the issue, and it is less time spent working with their colleagues so they can find a way to actually get something done. That is one of the costs of Citizens United. A second related cost, I think it's important to understand how lobbyists function in Washington, because at least before I came to Washington, I thought that lobbyists had a sort of nefarious influence where they could throw money around and they could be buddy-buddy. That's actually not why lobbyists are effective. A good lobbyist isn't someone who necessarily has a lot of money backing them, although that helps. A good lobbyist is someone that a member of Congress trusts to advise them. Members of Congress don't have much time, and they're spending 1/3 of it raising money. So because they don't have time to educate themselves on the issue, they have to rely on someone else to do it. And that service is increasingly privatized in Washington. That's what lobbyists do. The congressman needs to know right away about some complex health policy issue, so they call up the lobbyist who works for the health insurance companies, or they call up the lobbyist who works for the hospitals, or they call up someone else, not because that person is buddy-buddy with an interest group, but because that person knows the answer. And over time, as you take away more of these members of Congress' time, they're going to depend more and more on these individuals who aren't doing that job because they're there to serve their country. They're doing that job because they're there to serve their client. That is another way that Citizens United helps to increase the amount of corruption in D.C. So I will finish by saying that, I don't really disagree all that much. We started by talking about a need for common ground, and I don't disagree that there are powerful cautions that we need to have when we start talking about how people are going to regulate how we talk about elections. It's a dangerous place. But I am more frightened of the world that we are going to live in if our government is for sale to the highest bidder. And we cannot be so myopically focused on one threat that we ignore the threats that led to CEOs having to pull together their money to buy a meeting with a congressman, and people like me who don't have that kind of money being left out in the cold.
Well, thank you. Thank you. Now we have an opportunity for each of our speakers to have 5 minutes for rebuttal. We'll start with Tom.
Well, with all due respect to Ian, a lot of what he just said had absolutely nothing to do with Citizens Unite. Okay? He keeps saying using contributions to buy members of Congress. The amount you can contribute directly to a federal candidate is limited and has been limited for now almost 40 years. Okay? You can't give $100,000 to a congressional candidate. Right? The limit used to be $1,000. In 2002, it got up to $2,000, and it got indexed for inflation. So right now, it's about $2,600 that you can give per election to federal candidates. What we're talking about here are independent political expenditures. And none of the so-called corruption that he talks about, listen, if a congressman is engaging in quid pro corruption with a contributor, you know, if the congressman agrees he's going to vote a particular way, if he gets a contribution, that is against the law. And those cases get prosecuted by civil, state, and federal prosecutors. And if you have any doubt about that, do a quick Google search right now, and you'll find that the district attorney in Philadelphia is right in the process of prosecuting state legislators for that exact thing. What we're talking about here is you as individual Americans being able, for example, to join a membership organization on an issue you believe in. Let's say one of your important issues is abortion. Now, I don't care which side of that issue you're on. There are membership organizations that you can join. They're going to push the point of view that you think is right on that issue. Every single one of those organizations is incorporated and is a corporation. And I think that if that membership organization that you join wants to spend $100,000 or $500,000 of its members' money to go out and support, to buy advertisements independently that will urge people to vote for members of Congress that they think will vote the way they would like them to on that issue, you know, that's the system we have, and that's the way it ought to work. And I don't think the government should be coming in and telling them, you can't speak. I used to have to do that at the Federal Election Commission back when this law was in place. And I have to tell you, it made me very uncomfortable being a government bureaucrat who was deciding who could speak and what they could say. And that's the situation you would have if Citizens United were reversed.
I want to tell you a story about a man named Sheldon. Sheldon is Bond villain rich. Sheldon is so rich that his net worth exceeds the gross domestic product of 23 different nations put together. Sheldon is Sheldon Adelson, and I pick on him because Sheldon was also the top spender in the 2012 election cycle. He spent $150 million on the 2012 election cycle, which to him was about as much of a financial hit as if I bought a nice hotel room. This man is fantastically rich. He happens to be a Republican, and as I said, I'm picking on him because he was the top donor. There are plenty of Democrats who have this kind of relationship with Democratic politicians as well. Mr. Adelson, who gave this $150 million to help elect Republicans, got 2 private meetings with the then candidate for the Republican Party, Mitt Romney. I don't know what went on in those meetings. Sheldon Adelson is a very successful casino businessman. It's possible that Romney was thinking about opening a casino and he wanted some advice. It's possible that they just wanted to get together and talk about their kids. But I suspect the reason why a man who spent $150 million to try to elect politicians in one party decided to give 2 audiences with the presidential nominee of that party is because he had some policy ideas, and he thought maybe he would share them. You know, the distinction that Hans drew, the distinction that the judge drew, and the distinction that Citizens United draws between independent expenditures and donations directly to a candidate, and very little of that money, that $150 million I mentioned before, was given directly to candidates. Most of it was given to super PACs or similar organizations. The difference, the idea that somehow it won't foster corruption if you give money to a super PAC, because that candidate couldn't possibly find out who's giving money to these super PACs, couldn't possibly find out who their benefits are, and couldn't possibly be grateful to them and want to, say, have a meeting with them. In Mitt Romney's case, one of them in Sheldon Adelson's office in Las Vegas, and another one while the two of them were visiting Jerusalem. You know, again, the idea that no one knew who Sheldon Adelson is, or that no one knows who any of the other people are who are lavishing all this money on these donors is fascinating. You know, the idea that, you know, donors don't have mouths, and when they inevitably get the call from the congressman who is dialing for dollars, they can't say, oh, by the way, I gave $50,000 to the super PAC who supports you. Can we talk about this bill that I like? You know, the idea that that doesn't go on, frankly, strikes me as naive. And that is why I think this Citizens United case was wrongly decided. It's because in the process of drawing this distinction that I mentioned before between dollars for favors and dollars for access, it assumes that there's never going to be any kind of favoritism going on, just so long as the money goes through a separate organization and not to the candidate's account. I don't think that's right. I don't think the experience that we have had with people like Sheldon Adelson and others like him has borne out that experience. And ultimately, that's why I think this case was wrong. I think it was a case that comes from a lack of understanding of how the relationship between donors and candidates will actually work. And for that reason, I think it should be overruled.
All right, thank you. Let's give our speakers a big hand. Probably totally inapropos, but my gut reaction is that for $150 million, I'd want to have more than 2 meetings. That's just me. This is the time the audience has to ask questions. And to do that, we have a microphone on both aisles. We ask you to come down and use these microphones so that everybody can hear your question. We ask you to put your questions in the form of a question, if you would be so kind. Now, I'm going to exercise the privilege of the host and ask the first question, if I might. And it has to do, follow up on maybe the last subject that we were talking about or listening to. And that has to do with disclosure. We were reassured by Justice Kennedy in Citizens United that full disclosure would be a sufficient safeguard against unlimited spending corrupting the campaigns. And indeed, 8 out of the 9 justices agreed on that point. Disclosure of identification of the source of advertising was considered a permissible requirement and not an impingement on free speech because it enabled people to evaluate the arguments to which they were being subjected. The court said, and I quote, shareholders can determine whether their corporation's political speech advances the corporation's interest in making profits, and citizens can see whether elected officials are, quote, in the pocket of so-called moneyed interests, close quote. This transparency enables the electorate to make informed decisions and give proper weight to different speakers and messages. So my question to both of you gentlemen, if the Supreme Court agrees that disclosures are both permissible and desirable as a way of allowing the electorate to make informed evaluations about the source of the money behind the different political speakers, can you both agree that all substantial political donors ought to be identified?
Well, the problem with that is what exactly are you talking about? I mean, for example, political action committees, okay, the super PACs that keep getting mentioned, those are organizations that spend 100% of their time and 100% of their money on political activities. And if you are a political action committee, you have to register with the Federal Election Commission, where I used to be commissioner, and you have to reveal your donors. Now, on the other hand, if you are a nonprofit 501c4, which is IRS terminology for organizations like the NAACP or the Sierra Club, you cannot spend 100% of your time and money on political activities. In fact, the IRS has pretty strict rules about that. It can't be a majority of what you do. And the Supreme Court said a long time ago, and I agree, back in the 1950s and 60s, when the state of Alabama and other state governments were trying to get the membership information of the NAACP because they wanted to harass and intimidate its members, that was an interference with the First Amendment. Why is that? Because in addition to your free speech rights, the First Amendment says you have a right to freely associate with others. And today that rule is still there. The NAACP has no obligation to reveal its donors, neither does the Sierra Club, neither does Planned Parenthood, just because they may spend some of their money on political messages because they're concerned about certain people getting elected or perhaps not getting reelected. And I agree with that. Private giving, to me, is part of the First Amendment and an essential part of free speech.
Thank you. Comments?
So 2 thoughts on disclosure. I mean, I'm a supporter of robust disclosure laws. They aren't a substitute for, for a thoughtful campaign finance regulatory apparatus. I kept dropping the name Sheldon Adelson, so I'll drop it one more time just to remind you that we know who he is. The fact that we know who he is did not stop him from donating $150 million, nor that did it stop Tom Steyer, who's a Democratic billionaire who also spends quite lavishly on campaigns, nor did it stop a number of other people who spend quite lavishly. So I think disclosure is a good thing. It is not a sufficient thing. Hans makes a good point about the challenge that happens when you have an organization that doesn't exist solely for the purpose of funding political ads. Super PACs, largely, that's their purpose in life, and they are subject to disclosure laws. But what you saw pop up sometime after the rise of super PACs is you essentially saw sham C4 organizations that often didn't exist prior to the Citizens United decision, that popped up for the purpose of allowing people to donate money to someone that would run a political ad, and then it wouldn't be disclosed. I think there's a simple solution to that problem. It's the solution that used to exist for for-profit corporations, which was the way the system used to work for for-profit corporations is that if you were, say, the Ford Motor Company and you wanted to spend money on a campaign, you could do that. You would set up a political action committee, and your stakeholders, your employees, your officers, your shareholders, your board members could fund that political action committee if they chose to. And then the political action committee would then be the one that went out and spent the money. And so I think it's that method of separate accounting that can solve the problem that Hans described. If the NAACP was to set up a political action committee, that means that the NAACP can keep its donors private, as it should have the right to do so, except in the case when it's funding political ads. And through that separate account, you can make sure that only the money that goes to that separate account, only the donors to those accounts, are their identities disclosed.
Can I just add one thing? Sorry. Sure. And that is this. Let me ask all of you a question. How many of you voted in the November? I don't want to embarrass anybody. How many of you voted in the November election? Okay. Before you went in the voting booth and made your decision on who you were going to vote for, how many of you, let's say for Congress, how many of you went to the website of the Federal Election Commission and checked who had given money, who had contributed to the candidates that you were considering before you made your decision who to vote for? Okay, we have 3 people in the room. Now, how many of you feel it is essential for you to know who the contributors are to the NRA, for you to be able to judge whether you believe or like the message that they're giving on an issue? Absolutely nobody. The reason I ask those questions is I think disclosure, in many ways, is highly overrated, because most Americans that I meet, they make their decisions, for example, on candidates, on their character, the positions they represent. They don't really care who gave them money.
I think you're proving my first point. I mean, I think what you said is right, which is that, I think disclosure is valuable, and, there is a robust press that sometimes reports on what's going on with campaign donations. But you're right. Most people don't base their decisions off of, oh, I see that Tom Steyer gave money to this guy, so I'm going to go ahead and vote for the other guy. And that is why we need something more robust than disclosure laws in order to prevent corruption in our system.
All right, good comment, gentlemen. Thank you. Questions from the audience, and I see one volunteer right down here. An independently employed man, I can tell.
Yes.
Is that
Thank
just
you.
because you're wearing a tie? Is that why? Yes.
He knows more than he's willing to say. My question is addressed to Mr. Millhiser.
Mm-hmm.
You have spoken convincingly about the problems of money and politics and election. And your position was apparently adopted in McCain-Feingold by 50% of the Senate and 50% of the House and signed by the President.
Right.
So a lot of people agreed with you. And the topic of the debate is Citizens United bad for democracy? And you've answered yes. But you finished your remarks with it should be overruled.
Right.
And my question that I'm addressing to you is, given the status of what the law is now, on what constitutional basis would you advocate that it be overruled, since we can't have the court just being the decisions being determined on their results? There has to be a constitutional basis, and I'd be interested in knowing what constitutional basis, given where we are now, would you advocate that the court utilize I think your word was overturning the decision. Thank you.
Sure. So, I mean, if I were, through some extraordinary oversight of both the President and the Senate, appointed to the Supreme Court and assigned the task of writing that opinion.
Can I be a witness at that confirmation hearing?
By all means, odds. I would write it very much as I laid out in my opening remarks, which is to say, yes, there is a very robust First Amendment issue at stake whenever we talk about campaign finance. But what the court's precedents have consistently said is that the interest in preventing corruption of our elected officials can overcome those concerns. And so if you have a properly tailored regime, then it is permissible for that purpose. The flaw in Citizens United, like I said, is that it drew a line between two forms of corruption, labeling one as corruption and one as not corruption, that I do not believe in. And I would remove that line. I honestly, I haven't studied the entirety of McCain-Feingold closely enough to know whether there is an individual provision that I would strike down, whether there was another provision that I would uphold. But I would strike down Citizens United, and I would say that there should continue to be limits on corporate donations, because the possibility of corruption when you have the sort of mass aggregation of money that can only occur in the corporate form is greater, and therefore calls for greater regulation. I would say that we probably need more robust checks on individual donations. But the framework of the opinion you asked for the legal basis would be the fact that corruption is or the need to prevent corruption is a valid interest which can overcome the strong First Amendment concerns that are raised by campaign finance regulation.
I should say on that actually there was a bill introduced which I thought was shocking in the Senate recently to amend the First Amendment. First time, I think, in history that a bill was introduced and supported by a large number of senators to cut back on the Bill of Rights. People keep talking about there's just too much money in politics. I just kind of laugh at that for this reason. I actually pulled the numbers before I got here. There's a great website called opensecrets.org. I don't know if you all have seen that. They take FEC data. I'm sure Ian, you use that site too. They take FEC data and they put it up and you can see all kinds of stuff. But I took a look. In the 2014 election, right, the one we just ended, they estimate that there was about $1.6 billion spent in the congressional races. In the 2012, that's a two-year cycle, right? In the 2012 presidential cycle, 2 years, there was about $3.1 billion. So 4 years election cycle, the total spent by all federal candidates, Congress and President, was about $4.7 billion. Now, in 2014 alone, U.S. companies spent $178 billion advertising their products. The total amount spent on all federal elections for 4 years was less than U.S. companies spent to advertise for restaurants where you go eat. Now, the money that candidates spend is a form of advertising. They use that money to try to let voters know what their ideas are, how they feel about public policy problems, what their solutions are. And I don't frankly think that spending less money than is spent on advertising, actually on food and candy in the U.S., is too much money when you consider that that money is being used to try to educate voters on where these people stand so that we can make the right decisions for who's going to rule the country, the legislative branches. The other thing I would tell you is this. As you all know, someone famous once said the states are the laboratories of democracy, right? The states all have very different rules on this than the federal government. Some of them follow the federal model, but there are plenty of states, Utah for example, where not only are there no contribution limits, you can contribute as much as you want to candidates, unlike the federal model, but they also allow corporations and labor unions to not only engage in independent expenditures, but also contribute directly to candidates. You can look at the states that have that kind of open system. They have full disclosure, but they don't have the kind of limits. And Ian keeps saying we have this horrible problems of corruption. You look at those states, and I defy any of you to find states that that have huge corruption problems. In fact, many of the states with those kind of open rules, like Utah, Utah is regularly rated by Governing Magazine as having one of the best-run state governments in the country. So it's very easy to say, oh yeah, money, too much money is corruption, but you come down to the actual proof of it, and it quickly disappears.
So I'm happy to concede that there's more ads for Big Macs than there are for congressmen, but it's not clear to me what that has to do with the price of beef. So, just a few numbers to give you a sense of, what the pre-Citizens United world looks like, what the post-Citizens United world looks like. Between 2008, which was the last presidential cycle before Citizens United, and 2012, which was the first one afterwards, spending by non-campaign groups rose by 245% in the presidential election, by 662% in House races, and I'm not making this number up, 1,338% in Senate races. Now, I'm old enough to remember 2008. And what I don't remember in 2008 are jackbooted thugs marching through the streets taking my free speech rights away. I do not remember there being a lack of a robust debate in 2008. And I certainly don't remember rich people having a tough time getting their views out to the public in 2008. So again, there are concerns here. We wouldn't want government to go too far in regulating our campaign speech. But we lived in a regime in 1990. There was a case called Austin, which forbade corporations, which said that it was fine to forbid corporations from spending on elections entirely. I'm old enough to remember 1991, and I don't remember there being a lack of a robust debate about our politics in this country. So, I mean, to the extent that you are predicting a dystopia, we have lived in it, and I don't remember it being so bad.
Well, the counter I would have to that is if you all look at the campaign rules we live under today, okay, the federal rules on many of these issues were basically put in place in the early 1970s with a comprehensive reform passed by Congress. Those rules were good for incumbents and bad for challengers. If you look at the retention rates of members of Congress after these rules went in that Ian likes so much, the retention rates went up like this. And that's because rules that, for example, limit contributions to only $1,000, which was the rule for about 30 years, those make it tough for challengers to try to knock off members of Congress. And, you know, the whole purpose of this discussion today is to talk about was Citizens United good for our democracy? Well, I would remind you of a historical fact, which is this decision was made in January of 2010. What happened in November of that year? We had some of the most competitive elections for Congress that we had had in literally decades. So this idea that Citizens United is somehow bad, I think is belied by the evidence. We had very competitive congressional races, first time in a long time. We had very competitive congressional races again in 2014, where we had a number of states where something happened that doesn't happen. Incumbent members of Congress were beaten. That is very unusual given the way things have gone for the past 40 years because of many of these rules. I am a big believer, as I said, in the more speech we have, the better. And I do not think the government should be banning and censoring speech and deciding who gets to speak and how much they get to speak.
So, Hans, you'll forgive me if I suggest there might have been a different reason why you liked the result of the 2010 election. But setting that aside, so Hans does make a fair point, which is that it is harder to raise money when you're not an incumbent. And, you know, that is one of the reasons why there needs to be some caution in this space. But there's another thing that also concerns me. There's a study that a law professor published a little while back looking at judicial races. And what this study was, it was fascinating. So she looked solely at donations from business groups. And what she found is that Republican judges, this was in states that have partisan judicial elections, Republican judges, if they get money from a business group, they don't get money from a business group, doesn't much matter, they'll vote more or less the same way. But Democratic judges, once that faucet turns on and the business group money starts flowing, the Democratic judges start voting a whole lot more like the Republican judges. And I don't want to just pick on business groups here, because I'm sure you'd see the same thing, you know, if she had picked criminal justice groups, if she had picked racial justice groups, if she had picked, you know, groups that support a robust right to abortion, you know, whatever issue. What she found was that when the money starts flowing, yes, it might be true that it is easier to kick the incumbents out, but all the candidates start to look the same. You know, that's the problem. That when you have a narrow group of people that all the candidates are dependent on, you get a choice between two candidates that don't have much difference between them, because they're both beholden to that same group. And I am cautious about the fact that you don't want to have incumbents have too tight a grip on their seat. But in the process of replacing the devil you know, you don't want to replace them with the only choice to be another devil is just as bad.
All right, we're talking about state judges, of course, and not federal. Other questions from the audience? Yes, sir.
Well, I realize that cows will give chocolate milk quicker than this ever happens, but after hearing about this dialing for dollars and this tremendous increase in the amount of money needed to get elected, and pretty soon candidates are all saying the same thing because you got to get the money from the same people, because there's only 400 people in this country that have that kind of money to do it. Public financing is just not possible. But it seems like, I even had a Republican tell me this once, that unless there's public financing, you're going to have more and more corruption, more and more stalemate, right, more and more of a country you don't want to live in.
No, I'm a supporter of public financing as a solution. I mean, I think it has worked in several states. This is actually a solution. You're right that it can't be done right now. And the reason why is the same 5 justices who decided Citizens United. So what the Supreme Court has said in the public financing case. So the way that you got to make public financing work is generally how the system works is that a candidate has to show a certain threshold amount of interest in their candidacy. And once they do that, they get a lump sum of money. And the problem with that lump sum of money, oh, is my microphone off? Or? Oh, shoot. Okay.
I'll be happy to finish Ian's thoughts for him.
Just give this to you, Ian.
All right, thank you. All right, so the way you got to make it work is you give them a lump sum of money. And the problem with giving someone a lump sum of money, let's say it's $1 million. Well, $1 million is a lot of money, but what happens if a super PAC suddenly shows up with $5 million? Now you've signed on to this deal where you're only going to spend $1 million, and you're outspent and you're done. So what a lot of states tried to do is they said, if someone shows up, if $5 million shows up, someone shows up with an extraordinary amount of money, that's fine, they can spend it. You know, Han said he wants more speech. Well, here we're going to talk about more speech. That person gets to spend their $5 million, but then the public finance fund will give $5 million to the candidate that the ads ran against. So that way no one is caught disarmed. That is how you can do public financing. And the problem is that the same 5 justices who decided Citizens United said that that is unconstitutional, that system that I've described, because it deters the rich guy with the $5 million from showing up in the first place. So, you know, again, if we want to have more speech, I'm happy to have more speech. I'm happy to say that the remedy for speech, the remedy for one pot of $5 million is another pot of $5 million. But the Supreme Court, unfortunately, doesn't agree with me on that point.
Well, that's a gross oversimplification of that decision. But here's the thing about public funding. Okay, look, in the 1970s when they put in the current rules we operate under the federal sphere, you know, they put in a federal public funding program. The way that federal public funding program is paid for, all of you have seen on your tax return, there's a thing at the end where you can voluntarily contribute. Was it $3 now? Okay. When this program was first put in, about 30% of U.S. taxpayers contributed to it. As the years have gone by, the number of people who want to contribute to that has gone, if you graph the line, it looks like this. Okay, to today, it's only about 8% of people who want to contribute to it. The only way you could come up with enough money to switch to a public funding system for congressional campaigns is you couldn't do it through a voluntary checkoff. You could never get enough money for it. The only way you could do it is by taxing people to pay for it. And I have to tell you that I believe it would be a fundamental violation of my First Amendment rights to tax me to give money to political candidates who I don't like and I don't agree with, because you're forcing me to associate with them. So that is a basic First Amendment violation of the law. The other problem with this is that I frankly don't want, the people are so critical about the fundraising issue. But people tend to give money to candidates who they like and whose ideas they agree with. And frankly, when a candidate is out raising money, that's a way of trying to persuade folks that his or her ideas are the right ideas, and that's why they should give money to them. I don't think that's that bad of a system. I think public financing is a worse system than that. And I don't want to switch to a system where I get taxed to pay for people I don't like. And in fact, one of the problems with the federal system is, you know who's received literally millions of dollars under that public funding system? Lyndon LaRouche. You know who Lyndon LaRouche is? Right? He's this crazy guy, runs a cult, right? Been in federal prison several times for tax evasion. And when the FEC, he always runs for president, always qualifies, and then applies for public funding through the federal government. He's collected millions of dollars, and when the FEC tried to deny him money, he went to court and he won because the court said, you don't have the ability to choose which candidates you think are valid or not. If the person qualifies, they get money. And that's an inevitable problem with any kind of system like that.
So Hans, I think, makes a number of valid points. One is if we have a public finance system, we have to pay for it. And the reason why the presidential public financing system collapsed, I believe, correct me if I'm wrong on this.
President Obama collapsed it.
Yeah, well, no, the reason why it collapsed is because the amount of money that you get through if you're a presidential candidate and you agree to take the public funding is so much lower than the amount that a major party presidential candidate could ever raise on their own, that presidential candidates, I thought it was Bush, but who was the first one who said no, but I might be wrong.
It was 2008. Every year since that program has been in place, from the time folks got nominated by their parties to the general election, which was generally, 2 to 3 months,
right.
Every nominee of the major parties, Democrat and Republican, took the public funding. And by taking the public funding, they agreed not to raise money privately. That was the system up until 2008. And in 2008, what happened is John McCain took the public funding, got his, I think, $80 million for 2 months of campaigning. President Obama said, I'm not taking the public funding. And he raised, I think, 5 times as much for that election. And because he didn't take it, that basically collapsed the system, and there are no presidential candidates of either party who ever again will do that.
Right. So what he said, the reason why candidates aren't taking it is because you can raise just so much more money if you do it on your own. And so you can fix that problem by just making a bigger pool and making sure it keeps up with inflation. That's going to cost more. I think it's going to cost less than the cost of having all of our candidates be beholden to their donors, but that does cost money. And Hans said we have to pay for it. We do have to pay for it. To the Lyndon LaRouche point, Maine has a really interesting system that tries to get around that problem, which is in Maine you have to get a certain number of seed donors. And I think they're just $5 donations. You have to get so many thousand people to give you $5 in order to prove to the state that you're a serious enough candidate that you're worth getting releasing the public funds to. And once you clear that threshold, then you get the lump sum of money. So there are ways, who knows if Lyndon LaRouche has enough of a network that he'd be able to cross that threshold or not. But there are ways to create an obstacle that's going to make it hard for non-serious candidates to qualify for the funding. And in order to overcome, the primary constitutional issue here is that the government, one thing it is forbidden to do, or almost completely forbidden to do, under the First Amendment is engage in viewpoint discrimination. So you couldn't say that Democrats can get public financing or Republicans can't, or Democrats and Republicans can, but Libertarians can't. The government can't engage in viewpoint discrimination. So there has to be some sort of a neutral standard in place saying everyone who clears this bar gets the money. I think Maine has taken an interesting shot at making that work, and you have to pay for it. And the question that we need to ask is, is it worth shelling out maybe as much as $500, $600 million a year in taxpayer funding in order to not have our presidential candidates be beholden to their donors? I think it is, and that's also not a question for me. That's a question for the legislature.
All right. We don't have too much time left, but this is your chance to ask the experts. Two gentlemen who are obviously very knowledgeable about this. If you have straightforward questions, do not be intimidated. They are obviously very responsive. Question, please.
This is probably not a very brilliant question, but being in a democratic society, what I'm hearing and what I'm seeing with election is money, money, money. And what I'm saying is, I want to know about the people. And I'm always have been for a voice of the voiceless. Now, voiceless people don't have a lot of money. And maybe us in middle class don't have that kind of money. But the system now is run on money. The more you give, the more that you get into your, this last year ago, a few months ago, was awful with the phone calls all the time, particularly from one party. And I'm weary, and I'm saying the people who don't have that kind of resources, don't have that kind of money, who's looking at them? It's all money to get in. I believe when our founding fathers talked about freedom of speech and the right for free speech, they never expected it to be a monetary system. What is your thoughts about people who don't have those kind of resources?
Well, I've addressed that, which is that if you don't have a lot of money to spend on trying to get your ideas forward, then you do what Americans, I said, have been doing for 200 years, something that was so unique that Alex de Tocqueville commented on it in his book about America. And that is, people find associations, that they find other groups of people who share their beliefs, and they combine. I mean, you may not have a lot of money to talk about the abortion issue if it's important to you. But if you join as a member with Planned Parenthood, or you join as a member with an organization on the other side of that, you're multiplying your voice, and that voice can overcome that of particular individuals who may have a lot of money to spend on political speech. Any other alternative to that would be to say that how much political speech you have depends on how much money you have. And the more money you have, the less political speech you're entitled to have. That is not the system we have. That's not the way the First Amendment works.
All right. Anybody else? Another gentleman had a question. Question.
Hi. My question is along the same vein. Citizens United was determined based on the Constitution. Our Constitution is a couple hundred years old. Back when it was written, they added the Bill of Rights later. Corporations were chartered institutions that could be eliminated at any point in time. We had, we wanted the freedom of speech so that everybody could say what they wanted to say. There wasn't the money then. Right now it's like money is speech. So you have corporations with all the money and they can speak. My question to you guys is kind of a foundational question. What do you think our founding fathers, especially Thomas Jefferson, would think about the system that we have now and the constitutional aspects of where we are now?
So I might throw a bit of cold water here because, I think that the conception of the First Amendment that the framers have is something that none of us would want. The conception, as the First Amendment was originally understood, I believe this is the predominant view among scholars, is that the freedom of speech was a freedom against what are called prior restraints. A court or the government isn't allowed to stop you from saying something before you say it, but it didn't necessarily prevent the government from stopping you from saying something after you said it. And that strikes, or punishing you, sanctioning you after you said it, and that strikes me as a rather narrow and odious view of free speech. The Supreme Court in the 20th century expanded our free speech protections well beyond those bounds, and I'm grateful that they did. I think that, this is one reason why First Amendment law is hard, is because, the judge began by saying that the text isn't very informative because it's written in absolute terms, and yet we don't read it absolutely. And the history isn't very informative either, because the history shows that, the original understanding of the amendment is something that I suspect none of us would like. So we've struggled to find out, what we think those words, Congress shall make no law abridging the freedom of speech, should mean. And, I don't know that I have a comprehensive theory on that. I do know that I think the general conception that preventing corruption is important, and is sufficiently important that it will allow some robust campaign finance regime. I think that insight is a correct one, and I don't know what I really have to say other than that, because we're operating in such an odd area of constitutional law, where both the text and the history are very unhelpful to achieving an understanding of the amendment that I think anyone here would find palatable.
I think you get that when you look at the Citizens United decision and you read the Stevens dissent and you read the law that the Kennedy and Scalia try to marshal in favor of their position, and it's lacking. It's lacking in a lot of solid research. Not research. I mean, they researched, but solid law that really cast their position very clearly. They both make arguments. Hans, any thought on this?
This idea that corporations are something new and they're speaking, I think it was Scalia in the opinion pointed out that there were a lot of corporations and voluntary associations who actively petitioned Congress after it was first formed. In fact, in 1790, one of the first corporations to petition Congress in pamphlets and other things was an anti-slavery Quaker corporation. And the other thing
But that's not a profit corporation.
Yeah, but nonprofits.
You're talking about NCAA and things like that.
I'm not doing a debate with you. I'm doing a debate with Ian, okay? But this rule that we're talking about didn't just apply to for-profit corporations. It applied to nonprofit corporations of every kind. Can we do our finish-ups? Because I've got something that's kind of related to this.
All right. I had one quick question for you.
Okay.
If I could slip in, just change the gears one time, because this has come up recently. And it directly affects an article you wrote this past month, or a comment that you made, as a matter of fact. President Obama has made the claim several times that the Supreme Court ruling in Citizens United allows foreign corporations to spend unlimited amounts of money to influence our elections. Now, the Supreme Court seems to have specifically said it did not reach contribution and expenditure bans preventing foreign nationals or associations from influencing our national political process. But very recently, again, President Obama made the same statement. And I believe it was your comment to the effect, it was rather pithy, the President's statement is simply not true and will remain untrue no matter how many times he says it. So I think I understand your position. I'd like to ask Ian what his position, because I'm struggling to find a little common ground before we leave.
Right. Well, I should just mention on that this is not a gray issue.
You didn't think so, and you laid it all out very well in that article.
There's a federal statute that says that foreigners can't participate in American elections through money, direct contributions or independent political expenditures, and that provision has been enforced by the FEC. I enforced it when I was there with other commissioners, and the Supreme Court specifically said that its ruling in Citizens United did not reach that provision. That provision is still valid today. In fact, there was a subsequent decision where some foreigners came in and tried to say, oh, Citizens United means we can now contribute and participate, and the courts said, not the Supreme Court, but the lower court said no.
So I think it's a little grayer than you make it out to be, although
it's not.
If I were the judge examining the precedents, I think I would be inclined to say that Hans is right, but it is grayer than he makes it out to be. So the logic of the Citizens United decision is that it is unconstitutional to distinguish amongst speakers. So you can't say that Bob gets to speak and Joe doesn't, and you can't say that human being gets to speak and corporation doesn't. And if you take that logic seriously, then why can you say that Exxon gets to speak, but British Petroleum does not get to speak? If you take that logic seriously, then I think it does lead to where President Obama came out. Now that said, and the opinion that you mentioned dealing with foreigners was stronger than you made it out to be. There was a lower court which upheld the law saying that not individual non-U.S. persons are not allowed to give money to influence elections. That went up to the Supreme Court, and the Supreme Court did something very unusual. They did what's called a summary affirmance, which means that they said that the lower court was right, but they didn't issue an opinion. They didn't tell anyone why they reached that decision. So there's just the one time I know of where the Roberts Court has actually sided with the campaign finance law, and they didn't tell us why. So I think given those precedents, if I was operating under the Citizens United opinion alone, I'd be inclined to say that the logic of Citizens United also extends to foreign corporations. But given that the Supreme Court, for some mysterious reason that they are not telling us, seems to feel that there are additional limits on when foreign individuals give money, I don't think it's much of a stretch to say that that might also apply to foreign corporations.
And there we have it. Common ground, ladies and gentlemen. Thank you very much. So we have one more minute for closing at this time.
I would just end with this. I constantly hear people saying to me, corporations aren't, labor unions aren't people. First Amendment obviously doesn't apply to them. Well, I would have you think about this. If you believe that the Bill of Rights does not apply to anyone other than individuals, then you obviously believe that if, for example, the federal government, which has a huge deficit right now, decides that, Google is really worth a lot of money, and we're going to seize Google and nationalize it because all of the assets of it will be great for our deficit, well, then the federal government could do that under your view because the Fifth Amendment, which prevents the government from seizing private property unless it's for a public purpose and requires just compensation to be paid, would not apply to Google because it's a corporation. Also, it would mean that if the FBI decides that, Google might have information in its computers regarding crimes or perhaps a national security problem, we're going to show up at their offices and we're going to seize all their computers. And they say, well, we don't have to get a search warrant. We don't have to have a probable cause to get a search warrant because they're a corporation. The Fourth Amendment obviously doesn't apply to them. That's the line of thinking you're going down under that point of view. Because otherwise you're saying, well, yeah, some parts of the Bill of Rights, well, they'll apply, but others won't. And that's part of the problem with those who oppose this decision and start drawing those kind of lines. Thanks.
So, here we'll find more common ground. I do think the Bill of Rights applies to corporations. If the government wants to search Google's computers, they need to get a warrant. I don't think
we agree.
I don't think that's particularly controversial. The issue isn't whether or not the First Amendment applies to corporations. They do. It does. The issue, again, is whether a particular kind of regulation is sufficiently tailored in order to prevent a particular kind of corruption. And so the reason why historically there's been a line drawn between corporate speech and speech by human beings is that corporations are capable of they exist forever. They can amass huge piles of money that no one except for maybe Sheldon Adelson is able to match. And for that reason, we have recognized that when corporations spend on elections, there is a greater potential for corruption. But yeah, of course, the Bill of Rights applies to them. The government cannot take all of Google's assets. There isn't the same overriding concern where the government doesn't need to take Google's assets in order to prevent our members of Congress from being corrupted. But they do need to regulate both corporate and individual speech at times in order to make sure that that doesn't happen.
Thank you. As we conclude this evening's event, allow me to share a little secret with you. The next time you are at the corner of Ottawa and Lyon at the Kent County Courthouse, you may notice there are two triangular granite podiums situated there. You may wonder what they are. They are all that remain from Constitution Park, which was built next to the Grand River to honor the Constitution of the United States. The park disappeared with the expansion of the DeVos Convention Center, and after the two podiums were salvaged, they ended up in front of the courthouse. Why two podiums? Because like Hyde Park, Constitution Park stood for freedom of speech, and the two podiums stood for the significant diversification protected by our Constitution. Whether that diversity of opinion is found in our Congress, in our courtrooms, in our press, in our freedom to worship, or simply in our speech itself. The two podiums acknowledge that in this country, the freedom of speech is enshrined in the very fabric of our government. Now, perhaps we can no longer be able to stand in the Constitution Park, but I suggest the best way to honor our Constitution and the rights in it is to exercise them. And we have robustly done that this evening. So on behalf of Ralph Hauenstein and the Hauenstein Center, Louise Whitney, Joseph Hogan, and myself, please join me once more in thanking our two very special guests, Mr. Ian Millhiser and Mr. Hans von Spakowski. Okay. And gentlemen, thank you for helping us understand a very complex topic and finding a little common ground. Ladies and gentlemen, thank you for being here. And please drive carefully until we meet you again. Good evening.
Good job.